Hello, thanks everyone for joining us today to this our webinar, Venable's webinar on COVID-19, what your nonprofit needs to know. I'm George Constantine, co-chair of the nonprofit practice group here at Venable, and excited to offer some of these observations over the next hour or so. If you are joining because you thought it was a program on the unrelated business income tax, we rescheduled that because we felt we wanted to sort of hit this hot topic when we could, given all that's going on so recently on this issue. But we will be having that seminar on unrelated business income tax in May. And just a couple other plugs while I'm talking about it. We're going to have a program tomorrow, also a webinar on similar to this one, what employers should and should not say to employees to manage the challenge of the coronavirus. And that's at 2 o'clock Eastern time tomorrow by webinar, and you can access information about joining through our website. Our other regular nonprofit programs coming up, we have one on April 22nd, Technology Transactions for Nonprofits. It's at the lunch hour, 12 to 1:30. And again, May 20th is our UBIT seminar on the tax consequences of revenue-generating activities for your nonprofit. So for today's program, we've got a great panel with some really good experts. To my far left is Ann Gerson, a counsel in our nonprofit organizations practice, who does a lot of work and has over her career with nonprofit organizations on a number of issues, including transactional and tax matters. Right next to me is Ron Jacobs, who co-chairs the political law practice here at Venable, and Ron also represents a large number of nonprofit organizations, particularly trade associations and professional societies. And has been advising a number of our association clients on issues related to coronavirus over these past weeks. To my immediate right is Jennifer Przinski. Jennifer is a partner in the labor and employment practice at Venable, and Jennifer does a substantial amount of work with our nonprofit organization clients and has been neck deep in these issues as well as we all have on the coronavirus side. And finally, to my extreme right is Mike Davis, who is a partner who focuses his practice on insurance coverage issues. And obviously, a lot of those issues have come to the forefront with some of the cancellations and other activities that are happening related to this disease. So we've got a number of things we want to talk about today. I'll let Ron sort of run through the topics, and we're going to try to be real quick because we don't have a lot of time. We have a lot of expertise at the panel, but we also want to hear some questions from those of you on the webinar and try to get to those that we can. And those that we can't, we'll see if we can get to you offline or after the webinar concludes. So with that, Ron.
Great. Thanks, George. And thanks, everybody, for today. So we have sort of 5 broad areas that we want to talk about. Any one of which could probably fill an hour's worth of time, but we're going to try and give you the highlights as we go through all of these. In particular, on the employment side, Jen's going to go through some of the key pieces. As George mentioned, there is an entire webinar tomorrow on employment, but hopefully we can give you at least some of the good guideposts here. We'll talk about insurance, events, and what to do about events. And a lot of the employment and then sort of communication with your board, with your members, with others involved. And I think the important thing to keep in mind for today is that, this is a changing situation, an evolving situation. And I think also it's interesting how different some of the opinions are. Different columnists and officials whose views I value have written 180-degree opposite columns. One, it's not as big of a deal. Other, the world is going to end tomorrow. And, obviously it's somewhere in between, but it's really, I think, a fluid situation that we have to, the advice we give today may not be the advice we give tomorrow because something else changes. So with that, we can move on to the background introduction.
Well, so if you've been watching the news at all, you're familiar with the novel coronavirus named COVID-19. It's pretty much unavoidable at this point. But I wanted to give just a little bit of grounding and background. As Ron said, it's fluid and changing what we know about the disease as well as how people are reacting to it. But it is a new outbreak, and as of now, it's in about, I think 90 is already outdated. It's in 100 locations internationally now, in every country in Europe and in various parts of the United States. There's tracking going on through a lot of different government and world organizations. And even the CDC has noted that based on the current circumstances, it's likely the virus will be considered a pandemic shortly. And the range of reported illnesses
And breaking news, I just was informed that WHO did declare it a pandemic.
We are now living within a pandemic.
This just in.
Apologize, it was not on. But fortunately, I've been telling you things you probably already know. The novel coronavirus is rampant, and it's infecting people throughout the world. And the reported illnesses range from very mild to severe, and in numerous cases, the proportion is changing constantly, but it can be fatal. And accordingly, there's been a significant international response. There have been widespread efforts to mitigate the impact and the spread of the disease. There have been quarantines, limitations on movement, and other travel advisories throughout the world. Some examples. At the beginning of the outbreak, there was famously a quarantine of an entire city of 11 million people in China. And other countries are starting various levels of quarantine. Just yesterday, Italy switched from having travel advisories in just the northern part of Italy to all of Italy. Israel is now requiring a 14-day quarantine for any travelers entering the country. And other countries have imposed quarantines on travelers coming from specific areas. The U.S. has also imposed travel advisories. There's a level 4, do not travel to China, and level 3, reconsider travel, except for essential travel, to Italy, South Korea, and Iran. And based on the movement, it's likely that that might expand in future weeks. The U.S. Department of State has also recommended that travelers with underlying health conditions not travel by cruise ship, because when there is an outbreak on a cruise ship, as we've seen in the news, there's a high risk of transmission to others. And so these are all changing rapidly, and we can expect there may be more before there are fewer. But they're pretty significant, and there's been an international response. And this is affecting everyone, including nonprofits. And so what we're going to focus on today, this is kind of a high level. There will be restrictions on employee travel. Already, many organizations have prohibited non-essential travel, and some have prohibited all. There have been a number of event cancellations. Some have received widespread press, such as South by Southwest was canceled in its entirety. And similarly, nonprofits as employers, as well as for-profit employers, are all facing a changing definition of when it's appropriate for people to come into work versus working remotely. So these are all developments in the workplace that are applying to nonprofits as well as other companies. With that, I'll pass it to Mike Davis.
We're probably breaking a lot of rules by passing the same clicker back and forth between each other.
Thank you. So I'm going to briefly cover some insurance topics with you all. And, insurance can provide one thing, which is money. So this is an area where perhaps you have an asset that you can tap to help defray costs or expenses or losses, or if there are claims. Certain types of losses and claims may be covered by various types of insurance policies that you maintain, but like many things, the devil's in the details, and you'd have to pull out your policy and see what the particular language is. Let me talk to you about a few types of policies listed on the slide that might cover your losses. One is event cancellation. So as alluded to, if you have an event and it needs to be canceled, or you already canceled it perhaps, if you have event cancellation insurance, that can potentially cover you for lost revenue and expenses that you might have to pay, for example, to a hotel if the minimum number of rooms weren't booked. Business interruption insurance, that can cover you if you have an event perhaps, but also if your business is interrupted in other ways. Commercial general liability, that covers you for claims by third parties. But for example, if someone claimed, I got the coronavirus at your facility or attending one of your events or something like that, that policy could potentially cover you for those sorts of claims. Environmental policies. Environmental policies can cover you for decontamination costs. So if you have an environmental policy, and if it doesn't exclude viruses, and you need to incur additional costs to decontaminate, they could potentially be covered. Employment practices, that would cover you for claims by your employees. I know there's going to be a presentation later about particular issues with employees, but don't forget that there's insurance that covers certain claims by employees. And then directors and officers or errors and omissions type policies. Those could cover your directors and your officers, or perhaps even the organization itself, if a decision made by the organization was challenged. For example, if you decided to go forward with an event and someone later claimed that was a bad decision, those policies could potentially be relevant. But as I said before, the details are very important as to what your insurance says. So that leads us to some best practices. Number one, speak to your insurance broker and find out, if you don't know, what types of insurance do you have? What are the limits in that insurance? Gather all the policies from your broker if you don't have them, because it's very important to look at the unique terms. Provide timely notice to your insurers. If you cancel an event and you have event cancellation insurance, you should be talking to your insurer now. And remember, your insurance broker is not your insurer. It's important to be speaking to the insurer in addition to the broker. Mitigate your losses to the extent possible. Even if you have insurance, typically you will have a duty to mitigate, so you need to make sure you're minimizing your losses if you can. Document your losses. Keep your receipts. Track your expenses, and make sure you retain all your relevant records so you'll be able to document your claim when the time comes. And be aware that your communications may be discoverable by your insurance carrier. So if you send a note to folks about why you canceled, it'd be nice to know what cancellation causes are covered by your insurance before you do that, right? You don't want to take the position you canceled for one reason if that reason's not covered. Remember that your communications with your brokers are not privileged, so the insurance carrier may get them, so be careful what you say to your brokers. If you're in doubt, it's best to hire coverage counsel, insurance coverage counsel, because those communications are privileged. Those won't have to be turned over to your insurers. So now let's talk a little bit about a few types of insurance that are most likely to be relevant. Event cancellation insurance that I mentioned before. That's typically written to cover a specific event. Maybe you hold an annual event. Typically they're specialized in their manuscript, and meaning they're specially negotiated. So what someone else's policy says might be totally different from yours. So it's very important to look at the language of your policy. They typically cover lost revenue, increased expenses, diminished attendance, cost to reschedule, and perhaps other items as well. But some contain an exclusion for cancellation due to communicable disease. And it depends how communicable disease is defined. That's very important to look at in the policy. Some cover communicable disease, but not fear of communicable disease. So it's important, if there is a cancellation, to tie it to a recommendation from a government authority, if you can, or even a requirement from a government authority if you can.
Mike, one thing I know from a couple of policies that I've seen worth defining communicable disease, the coverage just changed a minute ago when George told us that there's it's been declared a pandemic, because some of the policies I've seen define communicable disease only as something that has been declared a pandemic or an epidemic.
Correct.
So what would have been covered yesterday is not covered now under those kind of policies.
Correct.
Actually.
That's exactly right. It's possible that refunds can be covered, even if the refunds are voluntary to folks that might be attending an event. It's also possible that hotel penalties, so to speak, are covered. But again, it's possible they're not covered. These are a scenario where you get what you negotiate in these policies. They're not all the same. Let's quickly talk about business interruption. So this can cover you for lost income resulting from either a decrease in or a suspension of your operations. Of course, you have the same issue as to what triggers it that we just alluded to before in event cancellation. It needs to be, you need to make sure that this particular trigger of a virus is covered. Losses must be covered by a covered cause of loss. So that's important to look at in your policy, is whether the specific thing causing you to have business interruption is covered. Some policies, and there's an example here so you can see the language, are only triggered if there's physical damage, either to your facility or a facility off-site. So that would be problematic, right? Because the virus is not going to cause physical damage. So you need to look for broader coverage if you can. Now, there's also insurance that covers you for third-party claims, meaning a claim by someone against you as opposed to just losses you've incurred without a third party making a claim against you. Commercial general liability covers, among other things, bodily injury. So this could potentially apply if someone claimed they got the coronavirus at your facility, for example. However, a note of caution, many policies exclude coverage for contamination, which can include microbial matter or viruses. So important to look for that in your policy. Environmental insurance is intended to fill that gap, meaning if I just said CGL policies, commercial general liability policies, don't cover contamination, which may include viruses, environmental insurance typically does. Typically, it will cover you, as long as viruses aren't excluded, from contamination-related claims, and it may even pay for disinfection. So if you maintain that insurance, it can be very valuable, and it might be something you want to think about obtaining in the future.
Thanks, Mike. And one thing to add on that, too, is those of you seeking coverage now for event cancellation, you can almost be assured that there won't be any for communicable diseases, or at least it will be carved out. I don't think the underwriters are willing to write those sorts of policies.
For new policies, that's a good point, correct.
We had a question come through on that point. Okay.
So now we're going to talk a little bit about specific things that can happen, including event cancellation. And I think this is another one where there's a bit of a snowball effect. The more events that get canceled, the more events that will get canceled going forward. And what we kind of thought in the past may have a few weeks may change going forward. And I think one of the other hard parts here is thinking about how soon do you cancel. In terms of, is there a threat that maybe lets you use the force majeure clause that we're going to talk about in a few minutes in some of the contracts to get out of some of the liability versus sort of canceling soon enough so that you have more of an opportunity to let your attendees know, let your exhibitors know, so that you can have a more orderly transition of things. And then the other part that I think is hard is if we want to reschedule, when do we reschedule? What is the time horizon where we feel like we'd be safe to reschedule? So when we talk about these events, I think there are, really, I lump everything in two buckets. One is it our event? Is this something that we're putting on that we want to decide whether we're going to cancel? Or is this their event, someone else's event where our employees or perhaps our members are going to attend, and what's our obligation to help understand, to either say, no, we're not going to go, or to cancel our attendance at that event. And really, all this boils down to, it's a binary decision of either go or no go. We're going to have the event, we're going to send people to the event, or we're not going to have the event, and we're not going to host the event. And so, those are really, the decisions, but there's a lot that goes into it. We're going to unpack a little bit of that right now. So on the question of other people's events, are we going to send employees? Jen's going to talk a lot more about the employment issues down the road, but really, what we're thinking about is, is there a risk to our employees to send them to this event? Are we being fair to the employees if we say, no, you can't go to the event? We've heard some stories from clients that, the employees, the organization has set a rule that they won't allow employees to take non-essential travel. And the employee says, well, wait a minute, this event, this conference, whatever it may be, is essential for travel purposes. So you've got to think that through and kind of balance and figure out how to protect yourself. And Jen will talk a little bit about that. And then the other piece is, how important is it that you attend? Is it really an essential event to travel to or an essential thing to go to? So it's important to balance those things. So George, how do we decide if we're going to cancel our events?
There's a lot that goes into that, and I know a lot of you are in the process right now of trying to figure that out and monitoring things closely. Obviously, probably the biggest risk to so many nonprofit organizations, particularly trade associations, professional groups, is there's a huge financial hit if you're going to have to cancel your event. You're expecting, for many organizations, this is the biggest part of your non-dues revenue. It might be the biggest part of your revenue overall. Now, we talked about insurance, and maybe you've got some good options there, and that's all part of what you analyze. But the first step, we would say you're looking at the financial exposure that you may have against for cancellation against the concerns that may arise from health and safety. And we'll talk a little bit later. I mean, we're approaching this obviously from the legal perspective, but there are some non-legal considerations that may come to the forefront. On the legal side, there will be more and more concern. Are we putting ourselves into a risky position by holding the event, which if you were to ask us about a week ago, we'd probably say that's probably a stretch that someone could sue over that. But now we talked a little bit about this now. I think that's shifting a little bit. Obviously, what you're probably hearing, what many of you are almost certainly hearing, is a large clamoring from your membership or your attendees or whoever would normally go to the event that they can't go. Their employers are saying no. And, very often, we wouldn't like to say this as, organizations that put on these great events, but for the companies that send people to these events as attendees, they're going to view these events as largely non-essential travel. They're educational, they're there for networking, they're there for perhaps business development, that sort of thing. But rarely will a company or an employer probably view these types of meetings that we're talking about as essential. So you're probably facing damned if you do, damned if you don't. Even if you do go forward with the meeting, you may have a very low attendance and then maybe some attrition damages in your hotel contracts and those sorts of things. So next step, look at those contracts and see what your fees will be, what the liquidated damages will be for canceling. Could force majeure come into play and help you? That's that provision that we're going to talk about that essentially says you're excused from liability if there are certain supervening events that are either acts of God or otherwise described as beyond the party's control that make it, and we'll talk a little bit about that, make it impossible, or maybe it says impracticable to hold the meeting. So we'll look at that, and then look at some of these other issues about the attendees, and the people who've already submitted registration fees. Mike talked about maybe insurance will cover the refund of those fees, maybe not. Depends on the language of the insurance company. Depends on your own the language of the insurance policy. Depends on your own internal policies for refunds as well. And the same goes for exhibit booth rental contracts that you may have and sponsor arrangements. So there's a lot of money considerations there, but also a lot of reputational considerations there as well. And most organizations have large sponsors, large supporters, and you probably want to get their feedback and input and buy-in before you make an important decision like this.
In one thing, George, that I think we've been hearing too is that there's, with general economic concerns, while the association may take a hit if they have to refund all of their exhibitor fees, they recognize that if they're members, they can't harm their members, and their members are looking at cost containment and don't want, a large sponsorship that doesn't get used out there on the balance sheet.
Yeah. And all important considerations. And then, finally, if you do have that event cancellation coverage, take a close look at that and also analyze what the liability might be and working with your counsel for going forward. And then there are also a number of practical considerations as well. We've been hearing from a lot of organizations that the pressure that staff of the organizations are getting from would-be attendees saying, I can't believe you're going to go forward with this. I can't believe you haven't canceled this yet. What we're going to advise is clear communications and ongoing communications. Having that go, no-go decision at a certain time is important. But also, make sure the attendees, the stakeholders know that you're watching this very closely and that, any decision or where you might be today might not be where you are in a week or whenever it is that you decide to make a final decision. And next. Thanks. So if we're in the point where we've got events, we've got other activities that we just cannot carry out and we decide against carrying out, we look to the cancellation provisions of the agreements of the parties that we're working with. Very often with many event contracts, the cancellation damages are going to be set out in the contract as a liquidated damages provision. That essentially means we as parties at the time we negotiated this contract are deciding that this is the damage amount that usually the organization will pay in the event of cancellation. Sometimes it's a sliding scale based on when notice happens. For many contracts, you're well within the highest range of cancellation fees at this point. even if you were to go forward and not cancel, look at things like attrition in a hotel type of arrangement, or other types of underperformance fees that you might be obligated to pay as well. And then the key provision that we've been looking a lot at lately is force majeure. And this is essentially this notion that I described before, that if there are events that happen beyond the reasonable control of the parties, that neither party will be liable for cancellation if those eventualities make it impossible, or depending on the terms of the agreement, may be impracticable to move forward. There are also common law doctrines that could come into play here. Essentially, if the contract is silent on force majeure, or the type of activity here, the spread of a communicable disease, is not well within the types of eventualities that are described in the actual terms of the agreement, you can look to what are these sort of common law concepts of impossibility or frustration of purpose that courts have said over years and years, that if you're contracting for something that it's literally impossible to go forward with due to these, unforeseen and actions by some entity that is not a party to the contract, then perhaps you're excused even without a force majeure way out. But those are very narrow, and we would say very difficult to rely on in a situation like this. And now Anne's going to talk a little bit specifically about the force majeure clauses.
Well, and because of the development of force majeure clauses through kind of a parallel of this common law development in various cases, where how do you handle an obligation to clean a building that has burned down in the intervening months, things like that. Force majeure clauses have developed and are phrased in a very particular way that to non-lawyers looks a lot like legalese, and are really kind of impenetrable until you understand the various elements. So we wanted to take a really specific dive into them, because if you do have a force majeure clause in your contract, undoubtedly it's what you're looking at right now to see if this current situation will impact your ability to cancel without penalty, or at least with minimal penalties. We'll get to that in a little bit. But so there's 4 major elements to look for in your clause. The first is if there's a specific list of the events that count as a force majeure. And force majeure, just as a side note, can sometimes also be called act of God or impossibility clauses, because force majeure is a French phrase that means major force, but it's often translated as act of God. And it's really meant to hit the things that you could not have known were a possibility going forward. And that's one of the reasons that it's also really helpful to see if medical epidemics are counted in your force majeure clause, because there are some articles and some commentators on the law who say at this point a medical epidemic may be an event that can be anticipated because of the recent outbreaks of SARS and H1N1 that also impacted the world. And so there's some talk that you may not be able to get it through the common law doctrine. So it's important to see what's in your contract. And these can list national disasters, they can list acts of terrorism, or the threat of terrorism. Here's another place to look, just like in your insurance contract, if it's a specific doctrine, or if the threat or the risk of something in your list is included as well.
And I noticed one thing that's not in here, but I think I've seen in some are act of government within some of these provisions.
That's a great point.
So that if the government makes it impossible to hold the event because of a travel ban, or that they've locked down a particular city where the event is going to be, that may be something else that could come into play. So irrespective of whether there's medical disease or epidemic, you would have the act of government piece to claim there.
Thank you, Ron. That's really helpful. And that may be what's happening in connection with South by Southwest, which was a prominent cancellation that we talked about recently that was done by the city of Austin, which may have allowed them to use their force majeure clauses. Well, I'll have to wait and see. And similarly, we talked about earlier, so I won't belabor it here, but the medical epidemics clauses may require a certain standard, which we now may be in. Depends on your clause. And also with the formal disruption of travel that may come from travel bans, government travel bans, or commercial carrier bans. Amtrak may decide to stop running. Greyhound buses may stop. So it makes it impossible for at least a significant portion of your attendees to get to your event. Sometimes force majeure clauses have that threshold, where if 25% of people or 50% of people literally cannot attend because they can't get there, then your clause may kick in as well. And then a clause that's drafted to be generous to the nonprofit holding the event may also include a catch-all phrase, such as any other occurrence beyond the party's control. And this gives you a little bit more flexibility to think of the unanticipated option. And then comes the part where clauses can really differ. It's the standard for excuse. And a typical one is rendering performance illegal or impossible. There's also if something is prevented from occurring, or there's commercially impracticable. And they all have various standards of whether or not you could meet it, but for the circumstance. For example, impossible is a much harder standard to reach than commercially impracticable. Commercially impracticable, we may already be there in certain locations or for certain events. Impossible is probably only one that right now you can't hit in New Rochelle, which is under a complete quarantine by the National Guard. So the standard is important. And then the operative phrase is the last part to understand what your real financial exposure is if your force majeure clause applies. Because it's not always a complete excuse for performance. It typically is. And then you're forgiven for the contract, and you're putting yourself into the position you were if the contract hadn't been in place, and so you could get a refund. But sometimes you can't. Sometimes you forfeit your prepaid fees. Sometimes you forfeit already paid expenses or certain payments. So they're not always 100% an 100% move back to where you were originally.
I think it's also, as you think about what each of these provisions in your contracts are, is that you may have 20 contracts governing an event, and they each may have a different force majeure clause in them with different vendors. And so you're stuck, you may be out of one but not out of the other. And so it can be a tricky exercise to figure out how to make yourself whole.
Ron, you're prescient. That's the next slide. And I'll run through this a little bit briefly because this is stuff that we've talked about already a little bit and will continue to talk about. But these clauses aren't always going to offer you full protection, especially because there are various ones throughout your various vendors. And so with one vendor, you may be able to get full forgiveness. With another, you may still be out all the fees that you've paid up until this date. And these clauses, as a general rule, are narrowly drafted. And sometimes they do lack specificity. So if you have a list of events in one clause for one vendor that applies, but you have just a general list with a different vendor, it may not apply. And as I mentioned before, the more flexible ones don't hold you to an impossibility or prevention standard. They'll use words like inadvisable, commercially impracticable, rather than just illegal or impossible. And it's important to remember, too, that even if you're trying to use this and even if you feel the clause applies and even if your counsel has advised you that the clause applies, it may not be simple to invoke it. This may still be a dispute. There's business considerations on both sides of the contract, and so there may very well be litigation that comes out of any organization's desire to invoke their force majeure clause.
Yeah, that's important. This is not an objective determination, far from it. So, even though you may feel you have a good position, you still may end up in a fight with the contractor over that position. The other thing that came up as a question that has come up a few times with us is, what about sort of the timing of the notice of the force majeure? Is there, sort of, a time at which it should be given? And that's very difficult to say because it's very fact dependent on the clauses in the contract. Obviously, the closer to the event, the activity that's being canceled, if there are more facts that can be marshaled as you get closer as examples of why it's impossible or commercially impracticable, the better. But there's a tension between those legal sort of being in a best sort of legal position and the obvious pressure and concerns and kind of black eye an organization could face if it just kept status quo as though the meeting were scheduled until, a day or two beforehand and then, quickly canceled. That may put you in a better legal position, but at a cost to your your member and sponsor and exhibitor relations. Okay, we'll minimize our passing of the remote.
I'll take all the
Good. So we're talking now. Good segue. It's as if I planned it. So we also have not just facility type issues, which obviously is so much of the discussion right now when we're talking about cancellation of events, but we have our own internal customers, our clients, our attendees, exhibitors, and the big sponsors. So look at you have to look at your agreements that you have with each of these parties. Is there a right of refund, or maybe oftentimes the agreement may have a credit for future events. The agreement itself may have its own force majeure provision. I do think most of the exhibitor agreements that I see tend to be one-sided in favor of the organization, but even those may have a force majeure provision, may have some refund provision or credit provision. Sponsor agreements, you're probably less likely to see a lot of specificity in there, just from my experience, and you're probably most likely among these groups to be able to sort of come to a mutually acceptable agreement as to what to do if you cancel an event and the sponsor loses its recognition, its visibility at that event. Find other activities, find other events for them. Keeping communications ongoing and as transparent as you can are really important. Again, keep in mind what Mike has said about reserving your rights under the event cancellation coverage while you do that. Just as an example. You often hear or see from organizations the health and safety of our attendees is our utmost concern. So if a cancellation decision comes, query whether an insurance provider would say, well, your reason for doing this was out of protecting them against their fear of contracting a disease, rather than the government pronouncement or the WHO pronouncement of this being a pandemic, or the employers saying that they won't send their employees to your meeting. The communication should be clear and transparent, but strategic as well.
Yeah, there was one recently where it really was, we took out the health and safety language, and it was all about the fact that the exhibitors were not going to show up because that was the more likely to work on the insurance. And that was the business reason why it was being canceled. I think the other language was added to make everyone feel good, and so we took out the feel good language. We're lawyers, so.
Right, and then other considerations. Obviously, many of you are probably already thinking about this, but is this an event, an activity that can be postponed to another date? Is the facility available in a reasonably good date, and time frame? You have to, from the perspective of the facilities, they're getting cancellation notices left and right, and they're probably being approached with postponement options left and right. So my hunch is that a lot of those later 2020 dates are going to be filled, and the more attractive ones definitely are going to be filled. But consider that and work with the facility if there's an availability for rescheduling. Finally, just what sort of logistically, how do you sort of mechanically go through the process of canceling? There could be for large exhibits, particularly if they're exhibitors coming from overseas, their booths might be on a slow boat that they put on there, 3 or 4 months ago to get here. They're the materials for their booth, for instance. So what happens when they arrive in port? Things that you need to think about and consider when making a decision like this, particularly for a large event. And what are the liability considerations? And this a little bit, I sort of prefaced this in my earlier discussion. Do we have event insurance? Do we have good coverage for these types of events? And what are the exclusions? Mike went into good detail on what some of these convention cancellation insurance coverages are like, sort of what they hit and what they don't. We've yet to see, I think insurance sort of tails this a little bit, right? So we may have some claims that are starting to be filed, but we've yet to see some strong evidence of what the underwriters' positions will be. And as Mike pointed out, a lot of these coverage policies are unique to a particular organization, so not sure how much we can take away from that. But definitely look for those exclusions and be aware of any requirement for the timing. I say that in the force majeure world too. Sometimes a force majeure provision of a contract will say you shall notify the other party of your intent to cancel due to this force majeure event within X days of the event occurring. Well, what is the event here? I mean, it's sort of this sliding scale of many, many things. What tips the scale? I mean, it's great to maybe be able to say WHO declared this a pandemic. That's the event. But the insurance policies may have a similar requirement in there. And then we talked a little bit about this duty to attendees issue. We have done some research on the issue. An association going forward with an event and an attendee gets sick at the event. Really, could the association be held liable because that attendee got sick at our event? Our thinking is there's still good defense from the perspective of you do what's it's a negligence standard. You do what an ordinarily reasonably prudent person would do. You would let put Purell out for people to have and make sure that the hotel has good cleanliness in place and whatever those sort of common sense steps might have been. However, now I think that the standard of care is shifting a little bit, and the fact that there are so many cancellations occurring, may give a little bit more heft to the argument that, well, yeah, association shouldn't even gone forward with the event, even with the steps that you took, because look at all these others in your world who have decided to cancel. Again, a very subjective standard, and one that I think still the association or organization would have a lot of defense for, but it is something to be mindful of. And I think over to Ron.
So just real quick, I think between this slide and the next, we'll talk about sort of proceeding as scheduled and then canceling, kind of things to think about. As George said, I think that the likelihood of option one decreases every single day as more and more events get canceled and as the disease spreads, quite frankly. But basically, think about your communication, your sanitation. If I get one more email from, a school telling me how they're wiping down the surfaces every other day or something like that, but it's important. Backup services. What happens when one of your contractors says, we're going to work from home. We're not coming in to do this work anymore. Whether there should be restrictions on attendees from certain places. Do we prohibit people from Seattle from coming to our event at this point in time, or wherever the outbreak may be getting worse? And then just be prepared for the decreased attendance if you're going to do this. Canceling, I think we've kind of talked a lot about the cancellation. Communication, when you're going to decide to make the decision, handle the contractual negotiations, who's going to be in charge, what is the communications plan, with letting people know, when do you, even within the decision-making process, if it takes a few days to make that decision, what are the messages you're sending out, while you're making that decision? Because the message to an exhibitor, we're probably going to cancel, could really undermine your insurance coverage and your ability to cancel the contracts under force majeure if you already were telling people to not book or not to come to the event. So you want to be really careful with sort of speaking out of two sides of your mouth.
And Ron, also before we move, I think investigating alternative options is something that organizations should be thinking of, particularly if you're canceling your event that is a major source of revenue for the year. And it'll be difficult to postpone because all of the other dates are already taken, or you can't get a significant enough credit with your venue to postpone and have it be financially reasonable. Then you can look at other smaller regional events or other activities that can help you both reach your stakeholders and generate some revenue.
Yeah, it's a really good point. So now we're going to turn it over to Jen to talk about the employment issues that come into play here. And so Jen?
All right, great. Thanks. Hi, everyone. So first I want to start with, why do we actually have to maintain a healthy workplace for our employees? Well, it's actually under the General Duty Clause of the Federal Occupational Safety and Health Act. All employers have to provide a place of employment for their employees that's free of hazards that may cause harm or serious harm or death. So that's why we as employers have to take affirmative steps to remove hazards from the workplace, like COVID-19, right? So to comply with that obligation. And the reason why that that you see employers stop sending, their employees to these conferences is because the workplace isn't just the physical office, right? It's anywhere where the nonprofit's business is being done. So the obligation extends out there as well. So with regard to ill employees, I'm not going to spend a lot of time on this because I think everybody knows. If somebody comes to work that's sick, send them home until they're symptom-free, right? If they call in sick, tell them to stay at home until they're symptom-free. That's pretty straightforward. But how about if an employee calls you and says, it's been confirmed that I actually have the virus, or an employee calls you and says, oh my gosh, it's confirmed that I've been exposed to somebody who's been confirmed to have the virus. What do you do? Okay, so with regard to the employee who actually has the virus, it's easy, right? Keep them home till they're symptom-free. With regard to the employee that's been exposed, again, removing that hazard, and quite frankly, my advice is kind of morphed, given the changing landscape with regard to the virus. Have them stay home for the recommended quarantine period. Just have them work from home. It's very easy. You can achieve that objective of creating a healthy workspace for your employees. But the more interesting question is, okay, well, what about everybody else? Do we have any obligations to the remaining employees who aren't sick? Do we need to tell them that somebody in the workplace was exposed to the virus or somebody in the workplace had the virus? And the answer to that is yes. Now, we're not going to send the blast email saying, John Smith has the virus, right? But what you want to do is let them know that an individual who has spent some time in the workplace, it's been confirmed that they either had the virus or were exposed to the virus, and reassure employees that you're taking appropriate measures, right? Sanitation, disinfecting, whatever that may be. And you're saying, why do you need to do that? And again, it's working toward your goal of maintaining that healthy workspace, and it's going to make employees kind of be extra cautious when they're determining whether they're well enough to come to work. And also for those folks who maybe have chronic illnesses that you weren't aware of, they might come to you and say, I actually need an accommodation in the form of telecommuting because I have this underlying chronic condition and I don't want to be exposed. They also might make some decisions based on your notification for personal obligations. Maybe they have an elderly household member or somebody at home who's chronically ill. So with regard to travel, I think this was really well covered before. You certainly want to be very cautious in determining what's essential and what's non-essential, right? And so once you determine what's essential and non-essential, whether or not it's to a high-risk area or not, you tell the employee, okay, well, this is essential business travel, and we would like you to go. What happens if they say, I don't want to go? What's the first thing you do? You need to actually ask why. Because if, like I mentioned earlier, they are disabled under the Americans with Disabilities Act, your obligation to engage in the interactive process to determine whether you can reasonably accommodate their disability has been triggered, right? And then you can work through that process, and quite frankly, it may very well be an accommodation of allowing them not to engage in the travel and sending up someone else instead. But even if they're not disabled, and there's no, like I said, I could talk a lot about this, but FMLA issues, right? FMLA leave issues. I'm going to put that to the side for a minute. But let's say they're not disabled and they tell you, well, I don't want to go. What are you going to do? You're the employer. Do you have the right to actually send them? Yeah, probably. But I think that there's practical questions here that need to be answered. There's definitely employee relations perspective. I think you want to work through with the employees to see what you can do. And again, try to understand why. Because if it is a family member at home that has a chronic illness or is elderly in their household, maybe you can send somebody else. And if they refuse to go, what are you going to do? Are you going to actually discipline them? Are you actually going to fire them if they refuse to go? If you could take that harder line, but I think you do have risks with regard to, OSHA, maybe negligence claims and the like. So just be careful and kind of think through that process, because there are some employees, my guess is you will find, that will say, you know what, I don't have concerns about this. I'm willing to undertake, this project and to take that travel. So a more interesting question, I think we've had a couple come through, is personal travel. So, well, it's fine to encourage employees not to engage in to engage in only essential personal travel to those restricted areas. We probably don't want to prohibit them. There may be some ADA implications, and I think you can actually achieve the same result by simply saying, listen, if you're going to be traveling from an X radius of our location, please let your supervisor know, right? And then you can determine, based upon that information that you get, what you want to do with the employee when they get back, right? Does it make sense to have them, stay at home and work remotely for a quarantine period or the like? So it really, again, I think achieves the same result without having to go through any risks of completely prohibiting personal travel to these risk areas. This is an evolving issue, of course, and so when you're developing your policies and procedures, just try to be as thoughtful and deliberate as you possibly can be. Tell your managers what your practices and procedures are. Why? Because we want to make sure everybody's doing the same thing. All the policies and procedures are being consistently administered, because the last thing you need at this time is a discrimination claim, right? So again, consistent administration is always a good thing. All right. Okay. So I think we're probably moving to some of you toward the office closure issues. And there's a couple implications here if we have an office closure. I think probably the most important that you would want to think through is the Fair Labor Standards Act and state wage and hour laws. Because if there's an office, with regard to office closures, you have different issues when you come to exempt and non-exempt employees. Non-exempt employees, it's pretty straightforward. It's easy. You only have to pay them for the hours worked. So if you tell them not to work and to stay at home, and because of an office closure, you don't have to pay them for it, right? You can tell them they can take vacation or PTO, but you don't have to pay them for that because they're not working. But it gets a lot more interesting when it comes to exempt employees. So with regard to exempt employees, in order to maintain that exempt employee status, they need to be paid the same salary every week, regardless of the amount of hours that they work, right? Unless it falls into one of those permissible deductions that we know about, right? You can deduct for partial day absences for FMLA leave or full day absences for personal reasons. But what doesn't fall under that exemption is if an employee is, quote, ready, able, and willing to work, and the employer doesn't have work because of business operation needs, like a shutdown, they're still actually entitled to pay. So what do? Here's option one. You can say, okay, exempt employee, and this is for those exempt employees who don't have the ability to work remotely, or maybe your office isn't set up for remote work, or maybe for some reason, financial reasons, you just don't want them to work. So option one, you tell the exempt employee, listen, don't work at all during the work week. No work at all. Because under the Fair Labor Standards Act, if an exempt employee doesn't perform any work during the work week, you don't have to pay them their salary, right? Now, when I say no work, I mean no work. That means shutting down the laptops, no checking emails, no taking phone calls, no work at all. Because again, if they work at all, you're supposed to pay them for it generally. So that option probably isn't the best one for a lot of you. So you can go with option two, which is, okay, you're going to perform some work, but when you're not working, you need to take vacation leave or PTO for that time off, right? Because what you end up doing is they're still being paid the same salary, right? You're just deducting the time worked from their leave balance, right? You're not making the deduction from the pay. It's just from their paid leave balance. And that actually is permissible under the Department of Labor guidance. And finally, this is a long-term option. Even though it's not in the actual Fair Labor Standards Act or the regs, the guidance says you can actually prospectively reduce an exempt employee's hours and correspond with their pay, right? So you could actually, and that for occasionally and for a long-term business need. So again, it's a long-term solution. Talk with counsel before you undergo this. But essentially, you would say to the exempt employee, and you have to give them adequate notice under applicable laws, but you would say, okay, we're going to reduce your hours, due to business needs, and your pay is going to be prospectively reduced for that time period. Finally, two more. If you lay employees off, they could file for unemployment, so you could have claims coming in. And then finally, if you're 100 or more employees, you may fall under the federal the WARN Act, right? That generally requires 60-day notice for mass layoffs, but there is an exception, unforeseen business circumstances, which would likely fall under, again, if you have 100 more employees and you're going to do a whole office shutdown, consult with counsel, and also check your state laws with regard to WARN, because sometimes state laws have WARN laws that cover employers that are smaller, have less employees. All right.
Thank you.
Thanks.
I think we're moving over to Ron, and we're concluding here.
So we're going to wrap up now to kind of tie everything we've talked about together. And some of this is summing up what we've already said before. But I think, as you think about how to communicate with your different audiences, there's a lot of considerations that come into play. And part of that, I think it's important to think about what your different audiences are so that you can make sure you've got the right message to that audience and the right level of involvement. In particular, when you're thinking about your board of directors, what do you tell a board of directors for a nonprofit about COVID? Are they involved in cancellation decisions for events? Are they involved in office shutdowns for remote work situations? And then, of course, all this ties back into budgeting issues, because typically the board will have oversight of the budget. So if you cancel an event that is a major revenue stream, the board's going to have to be involved in that decision because it's going to change the finances of the organization. They may not need to be involved in the decision to implement a remote work environment if you have remote work plans already in place and you can just sort of flip the switch and go to it because you've already planned for that contingency. But if you have to have a large outlay of funds to develop more remote access ports or software to be able to handle that, then it may also be a budgetary issue to get into.
Yeah, and with working with some groups on some of these tough decisions, one of the clients I work with made an excellent point, which is they were fortunate enough to have a good reserve fund, which a lot of nonprofits do have some reserve that they carry forward. And often people refer to it as a rainy day fund. And what this individual was saying to me is, like, if anything were a rainy day, this is it. So if you're talking to your board about these budget issues, this may be the time to, suggest dipping into the reserves, because clearly this is an unbudgeted and unexpected expense.
Absolutely. And then when you switch over to thinking about your members, if you're a membership organization, what is the communication like about event cancellation? What are we reducing the number of member services that we have? If we're planning, an in-person training session, maybe we can switch it to online or remote, something like that. But think about how you're communicating that to your members to make sure they still appreciate the value add that you're bringing to them. And then the third part with members is, are you thinking about doing some sort of relief operation? Are you thinking, gee, we should start raising money for different things? Think about how that comes into play, and again, the messaging that's important there. And then the employees, I don't think I need to say much more. Jen did a great job of covering there, but really I think, it's transparency with them, making sure they understand what's going on, so that they don't fear for their jobs if there's not a reason to fear for their job, or that things are going to change, so that you can make sure you're there. It's all very important. And then just in terms of all those communications that you're having, there are a few things I think to think about, which is to make sure you have the right message to the right audience so that you're communicating correctly. By the same token, be consistent. kind of back to my example before where you're, thinking about canceling an event, don't tell one group that you're going to cancel while the other one you're trying to, or the vendors you're trying to string along, because people are going to find out. It's going to be discoverable, and you want to be careful there. As we mentioned, preserve your rights when you're dealing with insurance claims, so be careful what you say that could shoot yourself in the foot for making an insurance claim or for making arguing that a force majeure clause applies. Consider privilege. If you're dealing with your attorneys, figure out who should be on that chain of communication. A broad email to a large group of non-decision makers, just copying counsel doesn't necessarily preserve privilege. If you're bored with counsel, more likely to be privileged, but think about that and make sure you've got a plan for how you're going to do that. Sometimes, an email to the board and counsel suddenly gets forwarded on to 10 more people, and then you've sort of erased the privilege that attaches, so be careful there. Transparency is important, I think, in this environment. I think that, the more you can communicate, generally speaking, the better you're going to be. Make sure people understand the process and what's going on. And then the final point is to be accurate. I think this is a very strange situation where, the facts are changing all of the time. The reasons for cancellation may be changing all of the time. Think carefully about what you say. One of the things I find fascinating is that unlike really any other sort of thing like this, even SARS and whatnot from a few years ago, the speed of communication is so much faster. And so take a step back, make sure what you're saying is accurate, because while I have some clients, we got to get a message out. We got to get this out. People are already talking about it. You want to make sure you're accurate, and you want to make sure that you think about all those other issues as well. So with that, we have a couple minutes left for any questions that may have come in.
We've been fielding them as they've scrolled through a little bit here, but one question that has arisen is, let me make sure I get the right one here. For Jen, are there legal considerations to allowing visitors into your office space?
Yeah, I think this is similar to what Ron was saying earlier when you were talking about allowing certain, deciding maybe certain people from certain areas wouldn't be allowed to attend your event. So, yes, I think to further your obligation to create a healthy workspace, certainly you can ask visitors a standard list of questions. But again, ask all visitors the same questions, right? And even, and make sure they're the same set of questions and apply that consistently. Like, yes, have you traveled to to these areas in the past, 14 days or whatever the questions are? You can certainly work with counsel. But again, the key there is to make sure that you're asking everybody the same questions, regardless if the receptionist or somebody else in the office knows them and we've seen them before. We just want to make sure we're treating everybody the same.
And someone else asked a question about the, thanks, Jen, about the this whole liability issue if we go forward with the meeting. And again, I feel we're speculating a lot there, so I don't want to get too far into the weeds on that. But the logical question that arose from one of the attendees was, well, does that mean if someone catches the flu, we're also liable, or cold or something like that?
And that's where the existing case law that's out there suggests not. I mean, even some of the cases that we looked at involve like cruise ships and sort of noroviruses that sweep the cruise ships. So that was kind of our initial thinking. But I think when you look at sort of some of the events where people have attended and the transmission rate seems to be so much greater with COVID-19 that may change sort of the standard of care. And, we now know more about it than we did 2 weeks ago. And so that may lead to a higher standard of care.
And I feel it'll be still very location specific too.
Yes, I think you're exactly right.
Well, we're over a little bit on time, and we could probably spend the rest of the day here answering a lot of these great questions. I do think we've hit a lot of the big ones as part of our presentation. So with that, I'll say we're closing the webinar. Really thank you for your participation. Encourage you to attend, those particularly who had questions that may not have been hit on the employment side, to sign up for tomorrow, because there'll be more on that. Thanks very much. Thanks to the panel as well.
Thanks, everybody.